anyway, thank you guys all for being here today. And we're very happy today to have Helen Newberry of the Center for Arkansas Legal Services. She will be presenting today on legal issues during a natural disaster. And I'll turn over to her.
Hi everyone, Helen Newberry at the Center for Arkansas Legal Services. I'm the disaster response attorney. Most of my practice is counties along the river, people who were affected by the 2019 Arkansas River flood. So I'm going to talk a little bit about legal issues that might pop up during a disaster in case you have clients that come to you about these things, or if you ever want to take cases pro bono whenever we have disasters pop up. So first I'm going to talk about FEMA, of course. FEMA has several kinds of assistance, but the one that you're going to be dealing with the most for your clients is the individual assistance. To be eligible for that assistance, the county that the individual lives in must have been issued a presidentially declared federal disaster declaration for individual assistance. So for example, during the 2019 Arkansas River flood, President Trump declared a natural disaster. As you can see on this map, these are the counties that were affected, and the counties that are in pink and pink hashtags are the counties that were where you could get individual assistance. Now, like the yellow ones, that was just FEMA just came in with funding for public assistance, just kind of like community support rather than individual assistance. It's a high standard. Even though the flooding was really bad, well, basically the flooding had to be really bad for this kind of assistance to be proclaimed. So FEMA awards benefits through the individual and household assistance program. There's 3 classifications for how your client could have gotten funding. There's temporary housing, housing assistance, basically home repair, and other needs assistance. So for temporary housing, it pays for a household who had to evacuate their home to rent a new place while repairs are being completed on their home. I actually had several clients who didn't rent a new home. They actually just went and stayed in a hotel. Payments are based on the area's median rental cost. So basically you just need your client to use the funds that they get and see if they can afford a hotel. So typically it's issued in 2-month increments. So in my example, one client in particular, she was staying in a hotel, and every 2 months she'd have to renew it, but her maximum time was 18 months. So whenever FEMA started telling her, well, we're probably not going to renew next month, then she started looking for a place to live. The length of time for eligibility depends on the household being able to show a continuing need for assistance. In her case, she was having other troubles getting the home repaired. So she pretty much just had to decide what to do at that point. Her home was still not livable, so she had to give up that temporary housing funding and go and find something she could afford to rent. There's also housing assistance. This is probably the most obvious kind of stuff. This is the money provided to the homeowner to repair the disaster-related damage. It should cover labor, cost of materials, and the goal, of course, is not to get your home back where it was. So let's say that you had a very nice heated floor in your bathroom, and your bathroom was one of the rooms that were destroyed in the flood. Well, FEMA is probably not going to pay to replace your heated floor. It's basically funding to make the home safe, sanitary, and functional, not to restore the home to the condition it was in before the disaster. The money cannot be used to repair the house to a better condition than it was before the disaster unless it's required by current housing and building codes. So this is something that came up a lot during the flooding as well. There were people who had houses basically on the river. So when the river flooded, their houses were inundated and had a couple feet of water in their houses. So to rebuild, a lot of those homeowners had to elevate their homes, put them up on, I've seen some up on stilts. I've just seen them elevated, where it's almost like the house is the second floor of the building, and then underneath is just pillars. Basically, you can get a little more funding to do that stuff, but it has to be required by code. And if you live somewhere rural, there's probably not going to be a lot of building codes to go by. But your insurance might ask that you repair to that condition before they'll cover your home. So there's also other needs assistance. This is medical, dental expenses, funeral costs, replacing personal property, storing your items while your home is being repaired, any damage to your auto, etc. A good example of that is actually FEMA is currently offering funeral assistance for COVID-19 victims. That was part of the last COVID relief bill, and the applications for that just opened, I think, a week or two ago. So that's an example of something that FEMA does for individual needs. So the amount of award is set. The Disaster Recovery Reform Act of 2018 changed those. And before the act, FEMA recipients could only get a maximum award of $34,900 for all three. That's the cost of the temporary housing, that's to replace and repair anything in the home, and to cover medical costs or auto damage or funeral expenses, personal property replacement. Obviously, it's not a lot of money. After that Reform Act, recipients can receive a maximum of $34,900 for the housing assistance to repair the home, and another $34,900 for the other needs assistance. And there's no maximum award limit for the temporary housing. And I think this is important because the median rental in some places is going to be a lot different than it is in other places. And if you can renew it every 2 months for up to 18 months, that can probably get pretty pricey. Somewhere like in the Bay Area, you're probably going to exceed $34,900 pretty quickly. There's also no maximum award for durable medical equipment, probably because that's also specialized. There's no telling how much those kind of things are costing in the long run. So when you spend the FEMA money, the money should be used for the purpose that FEMA gave it to you. If you get a $9,000 check and you use it to buy a new car, probably not smart. FEMA recipients need to keep the receipts for how they spent the money, and they need to keep it for up to 3 years. Basically, everything that they use to apply, all the proof, receipts, pictures, everything like that. Your client needs to keep that for up to 3 years because FEMA can audit the awards and do something called recoupment, which we're going to talk about in a second. So some issues I ran into when it came to, appealing FEMA awards or finding a client eligible are eligibility. You have to prove that you own the property. This is something that came up a lot for me. Clients who were living in mom's house, they had to prove that they lived there. I had one client try and get a personal property replacement, the extra assistance. She and her husband had been living with her parents, and they weren't able to get any money because her parents got money. So FEMA didn't issue more money for the same household. You have to prove it's your primary residence. If you have a home in Little Rock and then you have a home in Lake Village on the lake and the lake floods, if that's not your primary residence, FEMA's not going to give you any money to repair that home. Another thing is disaster-related damage versus deferred maintenance. I had this issue as well. I had a client whose home was very run down, and she had to do a lot of inspections. I think she had someone out 2 or 3 times to look at the property because FEMA was trying to deny her claim based on the fact that her property was already in poor condition. Another issue is proper use of FEMA money. Like I said, Was the money used for the purpose it was given? That's why you need to keep receipts for 3 years. Also, duplication of benefits. If you received money from another source, obviously, like your insurance, for the same damage covered by FEMA, then FEMA's probably going to want to recoup their payments. FEMA is basically just emergency funding for people who didn't have enough insurance coverage or didn't have any insurance coverage. So if you're doing your due diligence and you have the insurance you need, FEMA doesn't want to give you money on top of that. So if you represent someone, it can get pretty tricky. FEMA is very strict about who they're going to talk to. In my experience, they weren't super responsive. It kind of depends on who you get. You need to send them a signed document from the client stating the client's full name, the FEMA disaster number, and the client application number. For example, the Arkansas River flood was disaster number, I think AR-4441, and then the client application number was usually like 7 or 8 digits. You need to send the client address, the client date of birth and social security number, the scope of representation, what you're doing for the client. It's better if the signature is notarized. And if you have trouble with someone, call back and the next agent may be more cooperative. Sorry to say, but that's just kind of how it is with this. So if you are filing an appeal with FEMA, you have, of course, the 60-day deadline. FEMA will issue a written decision determining what benefits the applicant will receive. If the applicant disagrees, they can appeal. You have to file a written appeal. The appeal needs to be postmarked or faxed within 60 days of the date on the notice of decision. Of course, this is flexible. If you can show there was some kind of hardship, you can probably file an appeal much later. I think I did one as late as around 90 days, and it was successfully appealed. And the appeal can also be submitted online. So here's the address, FEMA Individual Household Programs. Here's the fax number. Christy sent out the PDF of this slideshow. So if you have to refer back to it, feel free. So what do you need to include in the appeal? You need to give an explanation why the applicant does not agree with the decision. If you're filing it late, you need to explain why it's being filed late and why your client should be given extra consideration, whatever their hardship was. Working at legal services, it's usually easier for me to explain why they're late because my clients face a lot of challenges, but it's going to vary from person to person, of course. Also in the appeal needs to be any new information that the applicant has, like pictures of the damage, repair estimates, length of repair, receipts for repairs that have been completed. Sometimes you can just make a claim that the person who did the original inspections didn't do a good job. I had that happen with one client where the FEMA inspectors aren't going to like climb in your basement that's destroyed to take pictures, but they need to gather as much information as possible. And I had a client who the inspector wouldn't even go in her house, and there was nothing wrong with her house. He just said he was there to look at the damage on the outside. Of course, you know, her laundry room had been flooded and there was lots of damage. So sometimes you just need to be like, look, this was not done right. And that's why I'm appealing. This letter, of course, must be signed by the attorney and the applicant. The applicant's signature needs to be notarized. That's one thing about these appeals and dealing with FEMA in general is you need to remind them over and over and over again of who this is and that they are who they say they are. On the first page of the appeal, the applicant needs to include their full name, current address, address of the damaged property if it's different, date of birth, place of birth, last 4 of the social, disaster number, FEMA application number, and every single page needs to have the full name of the applicant, the last 4 of the social, the disaster and FEMA application numbers. So I talked about recoupment earlier. That is where FEMA comes back and says that you were overpaid benefits. A A lot of times this is because someone will receive FEMA funding pretty quickly, and then their insurance will pay out to repair the same things. So in that case, FEMA wants their money back. FEMA calls this a duplication of benefits. Sometimes it also happens because FEMA has changed the way they interpret their rules. They might come back and say that you were overpaid because they made a miscalculation, which would be very unfortunate in your case. In a recoupment case, FEMA's not saying the applicant did anything wrong, but it's still going to come on the applicant to pay that money back. So the recoupment process starts when an applicant receives a notice of debt letter. Obviously, the best thing for the client or the applicant to do at this point would be to speak to an attorney, because at the end of all this, like any other debt collection, some people wait until they're already being garnished before they do anything about debt that someone says they owe. So this notice of debt will state that the applicant was overpaid benefits, needs to repay these benefits. Another problem that may come up is because the nature of disasters, it's often the home that is destroyed. So sometimes FEMA will only have the applicant's temporary address, or they'll only have their permanent address. And so there might be issues with mail. So it's important for applicants to keep their address updated with FEMA and to check in with them and make sure they have the right address. Because if that notice of debt is letter sent out and the client doesn't get it, might not matter. So if the applicant disagrees with the notice of debt, they can appeal in writing. They have 60 days from the date of the letter to file their appeal. Once again, this is probably something you could claim a hardship for. Since it hasn't yet been 3 years since the Arkansas River flood, I have not seen any recoupment cases for any of my clients. I hope I don't. Obviously, it kind of stinks, but I don't really think that there would be a problem with like claiming a hardship if it was a little later than 60 days. Once again, here is the address for the appeal and the fax where you can fax the appeal letter. You can also submit it online. In the appeal of the recoupment, the letter should have why the applicant does not agree they owe the money, a written explanation of why there wasn't a duplication of benefits. It's good at this point to pull out all those receipts and repair estimates, all that kind of stuff to show what the money was used on. It's good to pull out any insurance payouts, or if your insurance denied your claim, pull out that insurance denial. All that stuff needs to be sent to FEMA. For example, say it costs $50,000 to repair the house and your insurance only paid $10,000. FEMA paid $15,000. Your client can say this isn't a duplication because the FEMA money was not used to pay for the same repairs. It was used to pay additional repairs. Once again, letter needs to be signed by the attorney. Applicant needs to sign. That signature needs to be notarized. You need to send a photocopy of the client's state issued ID. The applicant needs to include their full name, the last 4 digits of the social, their disaster and FEMA application number on every page. And even though FEMA states that you can request an oral hearing, they generally make their decisions based on written documents. And when I did an appeal just on FEMA benefits, this was the case. I had one that they were really pushing back on. And so I just started demanding an oral hearing. And at that point, they just approved the whole thing. And there was no need for the oral hearing anymore. So if the applicant was overpaid and they lose the appeal, FEMA is going to assess the overpayment. They'll request the applicant immediately repay, of course. And if they don't repay, FEMA is going to use the resources available. Since it is a federal debt, they can garnish wages, they can put liens on property, they can seize tax refunds, the same thing the IRS can do. So if you are like me and you represent clients who don't have a spare $7,500 to repay to FEMA after they've misused their funds, uh, there is an option to tell FEMA this applicant has no money. They are in no position to repay. The applicant requests in writing that FEMA not collect. The applicant needs to show their monthly expenses and income. They need to write a letter explaining this is a hardship to repay. And sometimes FEMA can forgive the debt, either some of it or all of it, or even, of course, none of it. So, of course, FEMA is the federal agency for disaster and emergency management. There's also one on the state level, probably in every state, I'm assuming, but in Arkansas, it's called ADEM. It's the Arkansas Division of Emergency Management. They provide state level leadership and resources, and they coordinate a lot of the recovery and prevention. ADEM works with local governments, organizations, different agencies for disaster prevention and recovery. They're more on like the local level. ADEM also administers the state individual assistance program. And this is like the FEMA individual payouts, except, from the state. So homeowners or renters whose primary residence was damaged or destroyed in the declared designated area may qualify for this program. If you are a business owner, you can't get this kind of assistance. However, there is something called small business loans, the SBA, Small Business Association, small business loans, and those are available not only to individuals, but also to, of course, business. So to get this state individual assistance grant, the applicants need to call a contact a call center, or they need to go to a disaster recovery center if any of those have been set up. They're usually just kind of community booths. Here after the flood in Pine Bluff, we had one at a community center, and it had the Red Cross, FEMA, ADEM, just lots of different people were there to help disaster victims. There's also an online application. The application period is normally 10 days, and you have to meet the following criteria. Your damage must be due to the declared event in the right county. The damage must be done to the primary residence. Applicant must show or must allow the residence to be inspected. The applicant has to show proof of ownership, once again, like a mortgage statement or a deed, a title to the land, maybe even a contract for purchase. The applicant must show proof of residency, like some kind of utility bill or something going to that address. Only one applicant per household. Once again, if you are doubled up, say you and your husband are staying with your parents, you might not be able to get, well, you won't be able to get this if your parents get the assistance. You have to provide documentation for your insurance claim or settlement because of the disaster, because like FEMA, the state of Arkansas is not going to duplicate your benefits. And you also have to be denied assistance from the Small Business Administration. Like I said, individuals can get this as well as businesses. This is basically a loan. It's a low interest loan. The state of Arkansas wants you to try and get that loan before they're going to give you any money. Okay, so the first problem I'm going to talk about, the first legal problem is real estate problems. And we have this poll. Have you ever dealt with an heir property issue? Heir property is basically where you have a client living on the land that was an ancestor's, and a new deed has not been made out since that ancestor owned it. So now this land is owned by all possible heirs, basically in common. Oh, that's cool that some people have dealt with that. So, real estate title issues, air property is going to be a big one. For state and federal grants, the applicant has to show that they are the legal owner to the property. So, if you have someone living on land that is deeded in grandma's name and grandma has been dead for 30 years, that person might have an issue showing that they own the property, because basically they only have an interest in the property along with every other descendant of grandma. So this can create problems. Another issue is real estate purchase contracts. If something is basically rent to own, that might cause problems. I actually had a client who had bought a home that used to be a hunting lodge that was located on land that was leased out from Game and Fish. So it was very hard to show that she owned that when she basically just had a contract saying that she owned the house, because she didn't own the land. So it can get really complicated, and you can really learn a lot about the hazy ways people own property in this state if this comes up. Okay, so now we're going to talk about landlord-tenant law. That's always a fun topic in Arkansas. Did you know that Arkansas created no duty repair for landlords? There's no warranty of habitability, and that extends to disaster repair. So some states, like I know Iowa, has specific statutes addressing natural disasters and landlord-tenant laws. Requiring that a landlord either repair the rental unit or put the tenant up in another unit, or let the tenant out of the lease. We don't have that here. You're pretty much just kind of screwed. Arkansas law doesn't create rights or protection for tenants whose rental units were damaged or destroyed by a disaster, just like they don't create rights or protections for tenants who live in a rental unit with everything broken. If the property is destroyed or damaged so that the tenant's use of the property is substantially impaired, the tenant has the following choices. They can review the lease for provisions that address the issue. So a lot of times, especially if you have a good landlord, the landlord will actually put a provision in the lease that says that they will repair something. And they will say, this is how you get me to repair something. You give me this much notice or whatever it is. So in that case, the tenant may have some recourse to get something fixed. They can also negotiate an early termination of the lease. Overwhelmingly, this is the option. If most humans are reasonable, and therefore most landlords are reasonable, and they're going to agree to an early termination. Like I said, Iowa with their special law, like they require that not only the tenant get back the rent they've paid for the remainder of that month, it like prorated, but they also get their entire deposit back. This being Arkansas and there being no such law, you can ask for the deposit back, but I don't know how that's going to go. Another thing, if you do have a landlord who is unreasonable, you need to create a paper trail, some kind of body of proof of the damages, of what the house looked like or the unit looked like before the disaster, what it looks like now. You need to be able to show that you have attempted to negotiate a release, because if the tenant's forced to move out, if the tenant cannot live there because the place was full of water at one point, the tenant's going to have to terminate the lease based on constructive eviction for the landlord's breach of implied covenant of quiet enjoyment. And it's going to get complicated. So when landlord tries to come after the tenant for the remainder of the 6 months lease, you're going to want your client to have that counterclaim of, look, I was constructively evicted. The landlord will not work with me. I didn't know what else to do.
Hey, Helen.
Yeah.
There's a question, I think it might have went back to when you're talking about the heirs, but it says, what if they are the only one paying the property taxes?
that's really not going to make a difference. I mean, you can use that as proof to say that they were living there, and I have done that before. Like I said, with FEMA, if you're trying to get them to pay out benefits, a lot of times you just have to do everything you can to convince them that this person is living here and that they have at least constructive title to the property. When it comes to ownership of the property, though, if you actually have to go through a quiet title action, or you have to go through some kind of air property action, if you are actually trying to get title for the client, proof that the client is the one who's living there and they're the one who has been paying taxes will certainly help their case that the property shouldn't be subject to partition, but it doesn't really create any kind of legal protection to pay the taxes. It keeps the property from being lost, but that's about it. Okay, so mortgage issues. So the homeowner is obligated to continue making mortgage payments after the disaster. I know from my own mortgage that a lot of companies will have something that pops up on the homepage and says, were you part of this disaster? Because after the Arkansas River flood, I was getting pop-ups that said, were you part of this disaster? Were you in a declared disaster area? With COVID, getting pop-ups saying, were you affected by COVID? Did this disaster affect you? If the homeowner is not able to continue making payments, the homeowner should immediately contact the mortgage company to work with them. And even if you're not getting these pop-ups, but there's lots of options. There's forbearance of the payments. And at the end of the payment period, sometimes your mortgage company will just tack the payments on the end of the life of the mortgage, which means you just resume paying your normal payment. Another option is to become current once the forbearance is over. Another option is to just continue paying your mortgage payments with the prorated amount that you're behind, like tacked on to every payment. There's lots of options. Most mortgage companies are going to be helpful. If there is a mortgage on the house, any insurance proceeds will generally be payable to both the mortgage company and the homeowner. But the FEMA benefits will go solely to the homeowner. So basically, practically, a homeowner could have a mortgage on a home, get FEMA benefits, and run off. Like it could happen. So most mortgages contain contract terms regarding the use of insurance proceeds. Here's a little sample standard term. If you've ever read a mortgage, it's whatever. Whether repairs or restoration are economically feasible can become a point of contention between the consumer and the mortgage company. Let's say that you did have a house that was flooded and it was insured for $130,000, and your insurance gave you $100,000 to repair the home. But let's say that because of the flood, most of the earth underneath the home washed away and now half of the house is in a hole. It might not be economically feasible to repair that home at that point. And so that's where you're going to have to work things out with your insurance company or your mortgage company. Insurance proceeds checks are often made out to both the mortgage company and the homeowner. This protects the mortgage company. If the homeowner and the mortgage company can't agree, the remedy is generally a petition for declaratory judgment in not in district court. I don't know why that's in there, sorry, to determine the proper allocation of the proceeds. Basically, if you guys can't agree on how to cash this check, you're gonna have to get a court to do it for you. I do want to say, I didn't put this slide in here, and I did forget, but Something very important to know is if you live in a home that did not have flood insurance, and you or your client, whoever, lived in a home that did not have flood insurance, for example, FEMA paid out benefits in the max amount to repair the home. So the home is repaired, you properly use the FEMA benefits. You have to get flood insurance from then on out. If you got those benefits in 2019, and then, God forbid, the river floods again in 2022, if you did not get flood coverage for your home on your home insurance, and you try and get more FEMA money in 2022, you're not going to get it. This can also happen for people who buy the house after you leave. If they don't get flood insurance on the property, they might not be able to get any FEMA benefits because that property has already received a payout. So that's something people should keep in mind. If they ever do get FEMA benefits, they need to get the kind of coverage they need. They need to get the flood coverage specifically. Because the way the weather is, we're having these 10-year and 100-year events every other year now. So if you have a home that floods, it's probably going to flood again. So you probably need to get the appropriate insurance coverage. Okay, so contractor issues is something that someone might come to you with. Homeowners are often so desperate to hire a contractor to fix their home that they don't take as much care as they normally would. There's either a shortage of contractors, which I think happened a lot with plumbers after our February freeze, where everyone in the world had busted pipes. Basically, if you're a plumber, then you were real busy. So people get desperate and they just want to hire somebody who will get it done. Often, or they don't know what to do. They don't know who to call. So if somebody shows up at their door, they're like, well, my problem is solved. Often after a disaster, contractors will descend on the area, and not all of them are legitimate. And contractors often go door to door advertising their services. So here's something important to know, and this goes for any kind of door-to-door sales. There is an Home Solicitation Sales Act in Arkansas, where Arkansans have the right to cancel any home solicitation sale within 3 days of purchasing the item or services, as long as the item or services cost more than $25. The act is applicable when the purchase takes place at any location other than the permanent place of business of the seller. That includes when somebody comes to your door. That also includes if you go to a fair booth and buy something. If you go to a fair booth and buy some kind of water filtration system that costs $300, if you change your mind, you have 3 days to change your mind. The act requires the salesperson to verbally inform the buyer of their cancellation rights at the time of sale or completion of contract. The seller is also required to leave the buyer with 2 copies of the cancellation form and a copy of the contractor receipt. So of course, if you have a dude going door to door saying that he can fix people's plumbing, he's probably not going to have a contract. He's probably not going to have this cancellation form. So there are probably a lot of people out there who are violating this act. But of course, if we know the act exists, we might be able to do something about it and protect people who are harmed by these kind of practices. So when you do hire a contractor, even if they're not a scammer, there may be some issues that come up. The contract needs to be in writing. That's for everyone's benefit. That is to protect the person, hiring the contractor. That's for the contractor himself or herself. Is the scope of the work clearly laid out? It needs to say exactly what will be done, a timeline if possible. It needs to say how much this is going to cost, how much needs to be paid up front, if payments need to be made. I think probably a lot of people will say, well, I need the plumbing repaired in my home. Maybe this is how much down. This is how much to do the plumbing in bathroom 1. This is how much for the plumbing in bathroom 2. The contract being in writing and keeping receipts, making this record will protect everybody involved. Another thing that people need to consider when they are hiring a contractor, no matter how desperate they are for someone to fix their home, they need to know, does the contractor have the appropriate license for the work that they will be doing? I also say you probably want to see if they're insured. Has the contractor pulled the appropriate work permits from the city? So if you're living in the city and it's like a big job, you're going to need those work permits. If there are subcontractors, are they being paid? Because if you hire a contractor to, let's say, gut your basement, and part of that is him paying a subcontractor to refinish the plumbing, you need to make sure that the plumber was paid by the contractor. Otherwise, the subcontractor can put a lien on your property, even if you paid the contractor what you were supposed to pay them. If the city needs to inspect it, make sure that the final work product is inspected by the city and it passes. The most common cases of issues with contractors are where homeowners have made payments and the contractor has not started the work, or the work is only partially completed. This is a case that I had where someone knew someone from church, I think, and he promised to come fix this guy's roof. The guy signed over his insurance check to him to repair the roof. And the guy was like, okay, I'll be out tomorrow with new parts. And the guy showed up with old metal from roofs that he had demolished, from homes he had demolished. So he was using used parts after he said he would buy new parts. He also only worked for the roof that afternoon and then disappeared. And after months and months of trying to get the guy to come finish the job, my client had to actually have a volunteer organization fix the roof, because sometimes people just take some money and do a little bit of work and disappear. In this case, the homeowner can sue for breach of contract for the return of money paid. If partial work has been completed, the homeowner needs an expert witness to testify as to the value of the work completed. So if you have someone who was supposed to remodel your whole house and they only got about halfway done, you're going to need some expert witnesses to say what the value of the work done was. Another issue is maybe the work is not completed satisfactorily. So in a lawsuit, the homeowner needs to show through expert testimony that the work was not done correctly. So for example, that roof, if my client's roof had been repaired, the repairs had been completed, but because of that old bent up rusty metal, the roof was not correctly repaired and it was still leaking, I would have needed an expert to testify that that was the case and that the work was not done correctly. So if you do not pay for the work done on your property, the contractor needs to have some kind of way to get paid. One of the options are mechanics lien. This allows contractors, subcontractors, material suppliers, anybody involved in the process to put a lien on the improvement. And this includes an improvement to real estate, improvement to boats. And this is why I say, make sure your contractor is paying the subcontractors, because they can come back and get a lien as well. So I put a lot of information here about mechanics liens. I have never done one. On the reference page I made on the handout, I put the Arkansas statutes for reference. But just a quick overview. No lien may be acquired until service of the notice has been completed. There are service requirements in the statute. The owner of their improvement has at least 10 days prior to the filing of the account to respond. Basically, let's say that, back to the other example, the plumber was not paid by the contractor. So the plumber needs to give you a 10-day notice. Hey, I need you to pay before they can go and obtain a lien. So the plumber, if he gave you notice, he could go and attach a lien at the circuit clerk where the improvement is situated. He would have to file an account of the demand due or owed and an affidavit of notice showing that he gave you the notice to the lien account within 120 days of the completion of the improvement. So if the plumber didn't, the plumber didn't try to do a lien until like a year later, it wouldn't be valid.
Hey, Helen.
The homeowner, I'm sorry, did you say something?
Yeah, I'm sorry. I missed some questions a while back. Do you want to answer them now? Or do you want to wait?
Yeah, that's fine.
And I'm not 100% where this one came in, but the question was, can you place the money in escrow during this time?
I'm guessing that's for maybe repairs. I don't see why not. If both parties are agree to that, I think that's a good idea. That protects the homeowner from the contractor running off, and it protects the contractor from using his own money to repair the home and then getting stiffed. I think that's a great idea.
Okay. And then we have, perhaps you meant federal district court. It sounds to me like an interpleader action, which is much easier to make a federal case than others.
Yeah, I think that was where I was talking about insurance. I don't really know if I don't know if any kind of dispute, I think any kind of dispute with your insurance company or your mortgage company over the insurance might have to be filed in the circuit court, but I'm not real sure about the jurisdiction, honestly. But I can, that makes sense.
Then this is really just a comment. It says there's a lot of these cases. And then a question, reading that slide on mechanics liens, do we actually have boats owned by kings? Perhaps you meant any kind.
I guess I had a typo.
I didn't catch it. So
I mean, maybe some people who own a boat think they're kings. I don't know. I don't own a boat. But if anyone has, done a lot of air property work, I'd be interested to talk to you if you would want to email me or give me your email after this. Because it's something I've been thinking about, and it's something I would like to develop some kind of program within my organization that addresses those issues. So, anyone, who has any expertise or any tidbits of information, give me a shout. I would appreciate it.
We have a couple more questions that just came in.
Okay.
Now they're rolling in. A contractor who fails to give notice under 1844-115 could be guilty of a criminal violation under 51108. I have used that successfully against contractors who have threatened to file liens without giving notice. I guess it's more of a...
Oh, that's nice.
Okay. And then what if you ask for information about payments to the subcontractors and the contractor lies and says that it has been paid out but has not? Is he required to provide receipts during the repair process?
I don't think he's required, but I think as his boss, you can require it. You know what I mean? You can say part of this, you can put it in your contract. If this is going to be a big, complicated repair work or repair job, I think you absolutely should require that he files any receipts with you that he's used to pay subcontractors. Because even though it seems like, you can just hire a contractor and it'd be so much easier than having to hire a plumber, an electrician, a brick guy. If any one of them can come after you individually, you want to make sure that that doesn't happen.
There's a suggestion here from someone to draft the contract to require lien releases.
That's cool.
And that's it.
Okay. So here's some things that a homeowner can do if a lien is filed. The first option is to pay what's owed. If you owe what's owed, pay it. If the debtor does this, they need to keep a record. So apparently, if you do pay this, if you're the person owing the debt and you pay, the creditor has to enter that satisfaction of lien in the office of the clerk in 10 days. So it's a pretty quick turnaround on that. I'm glad to hear that apparently Arkansas law does a lot to protect people from mechanics liens. Like someone in the comments said, there can be a criminal charge related to this, lack of notice for threatening someone with a lien. And then of course you have the requirement that the creditor enter the payment has been made within 10 days, because otherwise the creditor will be liable to any person injured to the amount of injury and for the cost of the suit. Another thing a homeowner can do if they don't agree with the lien, they can challenge it in court. Of course, if it's under $5,000, they can file in small claims. If it's over $5,000, they probably need to hire you. If they challenge the lien, they can also counterclaim for money damages against the contractor. And I do believe I read somewhere in the mechanics lien statute that you can get attorney's fees if the person who owes the money doesn't answer the debt or doesn't pay the debt after the lien has been entered. Oh, so another thing a homeowner can do is they can contest the lien. They have to file a bond in contest of the lien. I have another typo. Good for me. But I think that bond is usually set by the clerk, and it's usually going to be probably around the amount that the creditor says is owed. Once the bond is filed, the circuit clerk has to provide 3 days notice to the person who claimed the lien. The person claiming the lien has to appear and question the sufficiency. And if they have not appeared and questioned the sufficiency after those 3 days, apparently the lien will be discharged, and the claimant can only have recourse against the principal and surety upon the bond. So like I've said, I've never done this. Don't ask me a question about that. If somebody has a helpful comment, that's cool. But I've never done this. And I actually got kind of lost in this when I was writing it. And I'd like to have an example in my head so it makes more sense. Okay. If a contractor puts a lien on the home, they can also file in court to enforce the lien. If the homeowner doesn't think the contractor did a good job, or the work wasn't completed, they can object to the amount owed. They can say, well, you did a terrible job and I shouldn't have had to pay you because of that. I think that's something that some famous businessmen have done before to get out of paying things, is to say, well, they did a terrible job. So insurance issues, I already said, if you have gotten money because your home was flooded, you got FEMA money, make sure you insure that property against flood damage from then on out, or you won't get any more FEMA money. So when you're helping your client with insurance issues, you need to determine what type of insurance the survivor has, the type of disaster, and the damage that was done. So if they don't specifically have flood damage, they're probably out of luck here. If their home is flooded, they're probably just going to have to rely on the FEMA money. You can review the policy to determine if there's coverage, of course. If there is coverage, the survivor should file a claim. In a claim, the survivor will want to be as thorough as possible, explaining the damage including pictures, what caused the damage, everything that they know is damaged, things that they think may be damaged even, an account of personal property. I mean, I think we should all really go through our homes and make a list of our valuable personal property to make sure it's insured with our homeowners or renters insurance. As always, the insured should submit as much documentation as possible, like a list of personal property damaged or destroyed. Pictures are helpful, even serial numbers, any available receipts, any estimates for repair work, any estimates for replacements. And anytime you get any kind of correspondence from the insurance company, review it carefully. If the insured does not agree with the insurance company's decision, they should get it in writing. So if the insurance company denies a claim or part of a claim over the phone, they should be giving that denial to the insured in writing. Review the policy for appeal rights and determine any recourse the insured has. Finally, we're about to the end. There can be education issues around disasters, especially for people who are displaced. So there's something called the Education for Homeless Children and Youth Act, and it was authorized under the McKinney-Vento Act, and it applies to children who are homeless as a result of natural disaster. It really applies to any child that is homeless. Federal law broadly defines homeless, such as if someone's parents has lost their home, they're staying with friends, and they're doubled up with relatives. They're living in a homeless shelter, a domestic violence shelter, in a motel, in transitional housing, such as like FEMA trailers. They're living in a campground. I think there were actually several people who experienced the flood that ended up staying in a campground for a while. If they're living in a car, if they're literally unsheltered, living in the street, if they're living in a public place, an abandoned building, these are children who are considered homeless. And of course, if you're displaced by a flood and you're living with grandma, you're considered homeless. So what's important about this is that homeless children have the right to attend either their school of origin or the local school. So if you have any client that is homeless and their child is having problems with enrollment, they have a right to attend the school either where they're staying or where they used to go to school. The local school is defined as the school where they're currently residing. The school of origin is where the child attended when permanently housed in the last school they attended. Homeless children have rights. They have the right to receive transportation to the school of origin. They are entitled to have all the services they receive transfer with them. So if they were getting some kind of speech therapy or some kind of counseling, they're entitled to have that service at the new school. They're entitled to enroll immediately, even if they don't have all the required paperwork. I know a lot of schools can be really particular about guardianships or powers of attorney, but the thing is, like, they can't turn kids away just because they don't have these specific paperwork. If you do have a student, or if you do have a client whose child has education issues, most disputes can be handled with either the principal, or for every school district, they have a liaison for homeless coordinator. And I think that's on the Arkansas Department of Education website. You can actually get a list of those people. If that doesn't work, there is someone who is in public school accountability, Dana Davis, and her information is here. Another problem people have, lost identification documents. They should have those documents in a fireproof, waterproof safe, or they should have uploaded digital versions. We actually have a self-help toolkit on our website that outlines important papers and like other things to prepare for a disaster. You can go to our website at arkansaslegal.org and click on disaster assistance. It's not always possible for people to evacuate these documents, but these documents are replaceable. Even birth certificates, immunization records, all this stuff's replaceable. People should always think about their bodily safety first. And that's it. Do we have any questions?
Yes, and this one came through, a little while ago, but it was, what if the person don't have the money for a bond?
Then you might want to challenge it in another way. Like I said, I've never done one of these. So I've never done the mechanic's lien. So I know that reading through the statute, there was a lot. Reading through the statute, it looks like there are actually several ways to challenge a lien. So just look for one of the other options.
Okay, we've got a few comments. 2 people said, great job, one excellent presentation, Helen. And then there's a follow-up to the comment about the court explaining, I guess, what was meant. If it is a state action between you and your insurance company, it probably would be circuit court. My point was the district court might be federal because divvying up money is basically interpleader, and that's much easier to send to federal court than typical diversity case. And in parentheses, Civ Pro may be too fresh on my mind.
So I guess, well, okay.
Yeah.
Civ Pro is not fresh on my mind.
Mine either. I'm like, it's way over my head. So just some more comments, very informative. Thank you. Thank you. I'm gonna check the chat real quick. I think they're just all saying thank you. Yep, great seminar, well done, great job, excellent presentation. This was a great presentation. The info on educational rights of homeless children was particularly helpful.
Good.
So, everybody, please remember to take the survey. It should launch anytime now. And if you don't get the survey, it should come to you in the mail by email tomorrow. You don't have to take it twice if you do it today and you get the email tomorrow, but please take it once you get it. And it is not anonymous, just so you know, because we do try to ask about volunteering in it. So we need to know who we're asking to volunteer. So yeah, anything else, Helen?
I know I usually have my information at the very end of the slideshow, and I failed to include that. I did say, hey, if you want to talk about air property, please reach out to me. My email address is hnewberry, NEWBERRY @Arkansas, all spelled out, legal services with an S on the end, .org. My phone number is 501-500-9384, and that number does receive texts.
Okay, I'm putting all that in the chat.
Okay.
The survey should pop up when we close out. Some people are asking. Okay, so I'm going to go ahead and stop. You're getting lots of comments of thanking you and saying great job still coming in.
Thank you.
And like I said, you may not see the survey pop up until you actually log out or until I actually hit end. So I'm going to go ahead and end it, and hopefully everybody will get the survey.